So, in the wake of this, we do need to talk about individuals like Maya Bradwell, who sort of challenged the established legal institutions of the time. And to do that, we have to look to Belva Lockwood, and we have to look to the amount of change that this one woman caused. So the struggle for women's rights, it's not as though it started in 1873 with Maya Bradwell. And it's not as though in 1879, when Belva Lockwood really begins to push for changes, that she was one of the first as well. But she perhaps is one of the most notable. In 1879, Congress passes a law which permitted women to be admitted to practice before the Supreme Court bar. So in 1879, Congress makes sure that women can practice in the D.C. bar and the federal bar more generally. The person who drafted the law and gave it to a member of Congress was Belva Lockwood. Belva Lockwood was born in Niagara County, New York. She eventually becomes a lawyer, and she passes the D.C. bar in 1873. She has to wait until after this law was passed. So the reason why she introduces this law, I mean, obviously twofold. First, to make sure that she can practice before the Supreme Court, but also to open the door for other women to practice. So after this law is passed, she becomes admitted to the Supreme Court bar, and Belva Lockwood is the first woman to argue before the United States Supreme Court. She's not done. In 1884 and 1888, she ran for president in the United States under what was known as the Equal Rights Party. She received a shockingly high number of votes, which should be notable because at this time, women did not have a universal right to vote in the United States. So what it means is that the significant number of votes that Belva Lockwood received in both 1884 and 1888, she was receiving from men. She continued throughout her life to work in areas of women's suffrage, and also argued cases for the rights of other individuals, which means that she brought cases before the Supreme Court on behalf of indigenous Americans. She argued cases before the court on behalf of the Cherokee tribe and other tribes within the United States. Herself, not a member of any tribe. She really begins to define and strike down in some very particular areas some of these gender-based distinctions. Many states, following the lead of Congress, began to permit women the right to practice law and be licensed in the bar. And so the decision in Bradwell, the Bradwell v. State cases, are ultimately rejected by many state legislatures, not all, but by many. So ultimately, and as was asked in the question, Illinois is one of those states, and Maya Bradwell is eventually admitted to the bar and allowed to practice within the state of Illinois. But these are early victories, they're hard-fought victories, and they're not a lot. Let's be very frank. They're not significant. To sort of give you the idea of how broad this was, the United States Supreme Court made a decision in 1875 called Minor v. Happerstedt that held that while women were citizens of the United States under the 14th Amendment, that amendment did not give the right to women to vote. So the Supreme Court locks out women from voting until states allow it. They pretty much, they end it themselves and put sort of on a path that there will have to be a constitutional amendment giving women the right to vote to overturn this decision. Remember, when the Supreme Court makes a decision based upon the Constitution, the only way to overturn it is to amend the Constitution. So in 1875, declaring that women were not guaranteed the right to vote via the 14th Amendment meant that there would have to be a constitutional amendment in order to remedy this. And while certain states could give women the right to vote, other states were absolutely inclined to deny them the right to vote. So while some states did grant this right, a great number of others denied it. And it isn't until the 19th Amendment is ratified in 1920 where we see universal women's suffrage. To sort of to cite some political science research in here, to bring it back to what it is that I actually do. What we found is that when women were given the right to vote universally in the 1920s, the turnout rate for women was shockingly low in many states, but it wasn't low in other states. And so one of my advisors from graduate school and his colleague at the University of Notre Dame went back and wanted to ask this question, well, why? Why were some states have such low female turnout rates and some states have much higher? And what they found is that the states that had given women the right to vote earlier had a higher voter turnout for women when the 19th Amendment was ratified. And the reasoning for this is, based entirely in political science. Voting, the nature of the act, is a learned process. It's something you learn to do. It's learned practice. It's the same reason why, no offense to any of the students listening to this, that when you turn 18 and gain the right to vote, your likelihood of voting is still monumentally low. Despite the fact you have the right, it's a process by which you haven't learned and participated in. And we see voter turnout rates go up as individuals age. The very similar thing happens to women. And so it isn't largely until the 1960s, during the peak of the civil rights movement, when we see Congress passing a number of laws that prohibited private employers from discriminating against women. And the reason for this should be obvious. It took about 40-ish years for women to begin turning out at similar rates as men. And when members of Congress realized that half of their constituency was women, they were willing to begin supporting laws which struck down gender-based discrimination. Interestingly, there was a congressional law passed in the 1880s which provided that females employees could not be paid less than their counterparts. There was a law. It was ultimately struck down. Who do you think passed that law, or urged that law to be passed as early as the 1880s? Belva, Lockwood. So while these early cases and traditions were so exceedingly permissive and based upon these stereotypes of coverture that was codified into law, there were individuals like Belva Lockwood, like Maya Bradwell, who were attempting to strike down these legal partitions that were set up in their way. But true systematic change did not happen until the pressure was put on the ballot box. And that pressure started as early back as Maya Bradwell and Belva Lockwood pushing for themselves to be represented in the legal community and pushing for the rights of women to gain the authority to vote. And once women, like everyone else, learned the power of voting, Congress began to make changes.